And if I remember this article correctly, there's a dispute going on in Portland, Oregon, where a council member has posted to Facebook. And so the question, there are a couple of questions that come up, is are the posts to Facebook public records? Is there some distinction that would be required as to whether it's a personal Facebook account or a governmental Facebook account? If it's personal account, but it's still only related to what this council member is doing in terms of working with her constituency, does that make a difference? Your thoughts?
Well, for starters, I would look at treating it as a PIA issue. I would start with the definitions in the Act, the definition of public record in particular, and I would look to apply that definition to the post in question. So that will lead to an examination of the content. Whose account it is it a government account or a personal account, could be relevant, but my take is that it's not dispositive of anything. I think the relevant questions to be asking are both content-based and functional questions as to how the official is using this account. Is the account being used to conduct public business, including communications with constituents about public affairs that the official is involved in or that are within that person's scope of duties? Is the account holder trading on, if you will, for lack of a better word, their status as a public official to draw in and to engage in communications with others? And that would really be the starting point. So I would not look at it as having a blanket answer across the board, but I would rather look to the context, the content, and functional use of the account. So clients don't like those kind of answers because they don't give you that litmus test. So the caution that I would give is that posts surely could be public records. We can all imagine posts that would be. We can also imagine posts that wouldn't be. But the caution would be to be mindful of the fact that they could be and that what you're posting could be deemed a public record and to treat it accordingly. That's my take.
I guess my only thing about that, and I've been trying to think this through a little bit, is ultimately it seems to me the PIA is meant to give an applicant the ability to get a copy of a record that they can't normally get a copy of. If I'm interested in the Twitter posts of a member of the Baltimore County Council, all I need to do is set up my own Twitter account and follow that person, and then, so why do I have to, as the county attorney, why do I have to find that thing for the person when my response is join Twitter, set up your own account, follow, Mr. So-and-so, and then go to his page and print it out for yourself. This is something that you can gain on your own unless it's been deleted. So I guess, that would be my inclination in that circumstance. And the same thing with a Facebook post or something like that. You actually, with a little effort on your part, Mr. Citizen, can get this yourself. That's leaving aside the record retention issues, which are very worrying to me.
Yes.
But in terms of the access, it seems to me that this is about giving records because they can't come in and look at our files themselves. So why should I have to worry about
Well,
that?
my take on that is, first of all, as an ombudsman, that I would be happy to convey that message to a requester and to ask them to, have they considered that? Have they attempted that? And so forth. As a county attorney, however, who might have an obligation to issue a PIA response to the request, if it is readily available online, for example, it's posted to your website, you would say, this is publicly available and posted to our website, available free of charge. Here's the link. if you have any problems accessing it, please feel free to contact me and we'll assist you further.
Which we do all the time.
Which you do all the time, and which is completely appropriate. If someone can't locate it on your website, has some other issue, I'm sure your staff would be happy to help them. But I think that's a perfectly fine response.
Well,
I think that's a fine response.
And I think in the Portland, Oregon situation, if I'm remembering correctly, the dilemma was that the council member had a personal Facebook page and blocked the person seeking to access it. So it's a little different than being the open sites, they
That's a
always,
completely different
you
question
can observe
also.
everything
Right.
out there, and
As to
so
whether or not
it's
that
just a
is-
retention issue. But here it was being blocked, but the council member was talking about different things that were happening during council sessions. So anybody have any other thoughts on that?
I think the analogy is, I have numerous municipal officials that use private email domains addresses, and they're doing public business. If I advise them that that's public record right there, be advised that you could be requested to divulge that, and you'd be required to do so. And so it'd be very similar when you have to put on a private Facebook page or a private email account. I think your analysis is spot on, that it could be, depends on what you're posting, who created that record, and what the business is involved in.
I think I saw a head shake though.
Yeah, I don't know, I guess one of the
Somebody didn't
questions though
agree.
is, does the public entity have an obligation to be able to recover those personal email or Facebook posts?
Well, as I said, the scarier question is the retention
Right.
question.
Right.
There's no good answer to that. Scares the heck out of me.
I think these are issues for the social media program in February.